Today's workshop is Bullying and Harassment, Know Your Rights. I'm excited to introduce you to Big Hartman, Esquire, the Vermont Human Rights Commission's Executive Director and General Counsel, and Amanda Lucía Garcés, the Vermont Human Rights Commission Director of Policy, Education, and Outreach. Thank you so much for joining us today.
Thank you so much, Karen.
Hello, thank you all. Welcome to our presentation today. My name is Big Hartman. I use they, them pronouns, and I'm the Executive Director and General Counsel of the Vermont Human Rights Commission. I just wanted to give you a little bit of introduction. Basically, I've been here at the Human Rights Commission for a little over 2 years. Prior to being Executive Director, I was an investigator here, conducting a range of discrimination-related investigations, including those complaints that arise out of schools as places of public accommodations. And I've been serving as Executive Director since July. Amanda, did you want to say anything more about your experience?
Yes, so again, Amanda Garcés, and I have been with the Human Rights Commission for 4 years now. December 4th is my 4-year anniversary. And I've I've done a lot of education work here at the HRC, chair of the education, and a working group that led a change to the education quality standards, which is currently rulemaking. And I do a lot of policy work and just education in general. I also serve in the Bullying and Harassment Council. So this is I'm very passionate about this topic. As someone who was impacted by bullying and harassment as a child and a teenager when I first arrived. So this is dear to my heart, and I'm here as a resource for you.
Thank you so much. Okay, I think we're ready for me to go ahead and share my slides. So let's hope that the technology cooperates with us today. And just one moment as I make this full screen. Okay, so here is our opening slide. Welcome to our presentation. Amanda, why don't you get us started?
Great. Yeah, so today we're gonna be brief in this 45 minutes that we have. We're gonna talk a little bit about the Human Rights Commissions. We're gonna give an introduction of bullying and harassment in school and our work within this. We will walk us through our legal framework and what that means. And then we'll talk a little bit about how to recognize bullying and some resources that we have in our state.
Yeah, just a little clarity where we say HHB, that will be explained as hazing, harassment, and bullying, which is, we often shorten it in our world to HHB.
Thanks for that, Big. So yes, so the Vermont Human Rights Commission works to promote full civil and human rights in Vermont. And we have 3 pieces in our jurisdiction. One is protecting folks from discrimination in housing, places of public accommodation, which could be schools, hospitals, even roads, interactions with the police, basically anybody that serves the public. Could look at restaurants. Yes, if you ask yourself, does it serve the public? That we protect from discrimination. And then we also have state employment. Any private employment goes through the Attorney General's office. The way that our structure functions, since we have 5 commissioners that are appointed by the governor, we are fully staffed. Yeah, for us right now, we have a staff of 7 full-time employees, mostly attorneys, our executive director, our executive assistant, and myself. And then we're going to walk you through this process of the complaint and investigation through it. But the statutes that kind of cover as our Title IX, Chapter 140, that's kind of boring, but just it's there as a resource when you get the PowerPoint. So how is the Human Rights Commission involved in enforcing anti-discrimination laws in our schools? So we look at our places of public accommodation, and this includes complaints of unlawful harassment, as well as allegation of failure to provide reasonable accommodations. Our office also may consider some IEP, individualized education plans, of 504 plans as part of our investigations that we do, but it does not have any enforcement authority over special education legal requirements. So we're gonna focus, this is a little bit of just what we mean by casing harassment and bullying. And we kind of attempted to do this as the plain language, not the actual legal definition, but so hazing, when we say, is if a student wants to join a school club or any school activity, and another student or a group will say to them, you know, in order for you to join this group, you have to do ABC. This could look like intentionally embarrassing, humiliating, or endangering their physical, mental health. In order for this student to join this group. That is what we call hazing. We've seen some cases in Vermont that have been horrific and have led to suicide. And so this is really one that we don't see enough, thankfully, but you know, it does happen. Harassment is when a student or someone who works at a school system does things to hurt others. This can make it hard for them to learn, their feelings are hurt a lot, or this takes away their rights to be able to be in school safe. And it happens mostly because their person's race, their national origin, identity, disability, religion, or other things. So it's basically bullying, but tied to this protected class. We'll go a little more in depth around this, but it has to have that component. And then with bullying, do you want to add something, Vic?
No,
I thought you.
sorry.
With bullying is when a student or school staff members pick on another student again and again. So it has to be repeated over time, and they do this to make the student feel bad or scared. Happens in school hours, but it could also happen on the bus, during school activities. Right now, we know that there's a high prevalence of this happening online, and it just makes the student feel unsafe and not want to go to school and hurt and all the things. So we have this continuum of behaviors, what happens, and then you'll have this for you to think. Sometimes, if a student or your child comes or to say that they're being rude, that people are being rude to them for ABC reasons, sometimes it's in that rude behavior of, my friend rolled my eyes at me, or somebody laugh at something I did, but it just kind of happens once in a while, and they're just people being rude and not kind. Ignore someone when someone's talking to them. That doesn't necessarily mean that it's being bullied. When we talk about bullying, which is like the next stage, is like it's because of their weight, their clothes, where you live, height, age, hair, whether they're perceived low intelligence, whatever that means, socioeconomic status, that we see a lot of that, but it happens over time and is repeated. Then we go to the next one, which is then how it gets into the harassment. So it's kind of like the same feelings of bullying, but then we are adding a protected class, a protected category, as we call it. So that's race, religion, color, national origin, marriage status, sex, sexual orientation, disability, gender identity, and also happens over a period of time and is repeated. Sometimes it's a single incident, which is severe. And then the last one is just, flat out criminal behavior, which is like physical or sexual assault, and hate crime, or cyberbullying. that could become criminal behavior. But so it's all, there's not much nuance around there. Next slide, please.
Okay, I
And
think
feel
now
free to add. Okay. Oh, yes.
did you want to add something?
No, go ahead.
And just to go back to the continuum, I will say, as someone who's conducted a number of investigations involving harassment in schools, it can be, what I want to say about that is that the behavior can be peer on peer. So it can be students who are engaging in harassment, or it can even be adults in the school. Teachers, TAs, staff members can also wind up committing harassment. Sometimes it can be a remark here and there. Sometimes it can be a more concerted long-term series of behaviors. And what we know is that there's a lot of these types, this whole continuum of behaviors that are happening in schools that aren't reported, that we don't know about. But what we do have is a legal system that is trying to protect students from this type of behavior and to impact some obligations on administrators and staff members in schools to take action when they do witness or learn of any range of this type of conduct. So we'll get into the legal framework now. Under Vermont law, and we are going to focus our discussion today on how Vermont law is impacting these issues. There are, within the state, legal framework, we're also all kind of underneath the umbrella of various federal laws that are at play as well. And some of those are very comparable, similar standards for reviewing the actions. But under Vermont law, school districts are required to implement policies and procedures for the prevention of hazing and harassment and bullying. So those requirements are within Title 16, Section 570 of our Vermont statutes. And in accordance with that directive, the Agency of Education in Vermont issued model policies and procedures in 2016. These are meant to represent the basic requirements. And if the school, at this point, I believe all school districts have policies, but if they don't, the model policy is presumed to apply, as well as the procedure. Where you as a parent will usually be able to find a copy of your school's policies and procedures will be in the school handbook. So usually those are available online these days. They're not often printed out and handed out too often. And the U.S. Department of Education Office of Civil Rights does have authority to investigate complaints of discrimination and harassment, as well as our office, the Vermont Human Rights Commission. We can investigate and litigate claims of harassment and other types of discrimination that occurs on the basis of any legally protected category. So that's, just to be clear, that's really not going, our authority does not go to address issues of hazing or issues of bullying unless a legally protected category such as race, sex, sexual orientation, religion, the other protected categories that we were just listing off, unless those are at play in the conduct. And also, I think it's good for folks to be aware that the U.S. Department of Justice Office of Civil Rights is also another avenue where litigation involving discrimination, which includes harassment, under federal law can be at play. And in Vermont, we have the U.S. State's Attorney Office of Civil Rights, which can be a resource for folks. However, they do address sort of, they don't, and none of these offices represent individuals, but either doing investigations or pursuing potential litigation as an enforcement mechanism for these legal protections. So what I thought I would do was proceed by just going down through what AOE's model policy and procedures spell out, because all the individual districts that implement their policies have to contain these basic provisions. They'll often have some more details and they may have some additional language, but this serves as the baseline of what's expected. So schools must adopt procedures for hazing, harassment, bullying reports and complaints. They are required to designate specific individuals to receive those reports and who serve as equity coordinators for the district. So in your schools or your districts HHB policy, you should see the named individuals who are the people who anyone can report this type of conduct to. And schools, most importantly, are required to promptly and effectively address complaints of hazing, harassment, and bullying, including taking action on substantiated complaints. So the policy also makes clear that any remedial action that a school takes to address a complaint must be reasonably calculated to stop the conduct, to prevent it from reoccurring, and to remedy any harm when that's appropriate. So the procedures are a separate document that go much more in depth about the specific requirements that schools need to follow. So I've highlighted some of the most significant sections of this, and if you're really interested in reading more, I encourage you to download these documents from the Agency of Education's website. There are provisions around student report of conduct. Any student who believes that they've been hazed, harassed, or bullied under the policy, or who witnesses or has knowledge of that type of conduct that they reasonably believe might constitute hazing, harassment, or bullying, should promptly report that to the designated employee or really any other school employee. Sometimes they don't know who the designated employee, but there is an adult in the building who works there that they trust, and it's perfectly acceptable for them to report that to that individual. Because employees have their own duty to report the conduct. Any school employee who witnesses, overhears of, or directly receives information about conduct that might constitute hazing, harassment, or bullying must immediately report it to the designated employee, and then they're required to fill out what the school calls a student conduct form. So again, this is not an investigation. This is any information that could be considered hazing, harassment, or bullying is supposed to initiate this process of reporting. And if an employee actually witnesses conduct, they are required to take reasonable action to stop the conduct and to prevent its recurrence. So there's also anyone else who witnesses conduct that they believe might reasonably constitute hazing, harassment, or bullying should promptly report it to a designated employee. So that could be you as a parent who is at school for some reason and witnesses something. The best thing you can do is report that conduct to the people who are designated to hear about it. And I always want to mention about false reports. The procedures do provide that if someone knowingly makes a false report, they would be in, that could result in serious disciplinary action. But if someone is making a report that's based on a good faith belief, that they are not going to experience any adverse action for making that report if it doesn't wind up actually having been found substantiated. I also want to make folks aware that in addition to, or as an alternative to filing a harassment complaint with the school, a person may file a harassment complaint here with our office at the Vermont Human Rights Commission or with the U.S. Department of Education Office for Civil Rights. I think it's always a good idea to start with a report to the school so that the actions can be addressed promptly. These administrative processes at the HRC and at the Department of Education take a lot of time. And so if it's something that really needs to get addressed immediately, you always have the alternative to come here. You have the option to come here. But I think if, to address the problem head on, making the school aware of what needs to get reported is a really important step. And once those student conduct reports are submitted to the designated person, there are some very clear requirements under the model procedures. A school administrator must initiate an investigation within 1 school day after receiving notice of information that hazing, harassment, or bullying may have occurred. There are some special circumstances. They might need a little more time depending on the timing of the report, but they really do need to take action to start an investigation right away. And it is common that administrators themselves are the people who conduct an investigation. That often depends on resources, but they also have the authority to assign someone else to conduct the investigation. And the parents must be notified. The parents both of, assuming that the students involved are minors, they need to notify parents. If the students are legal adults, then the students themselves must receive this notification that 1, an investigation has been initiated, 2, that retaliation is prohibited. So that means, a warning that you must not retaliate against anyone involved in this investigation or this report. The school has to notify the parties of rights pertaining to confidentiality, and I will get into that a little bit more because I know it's an issue everyone always has questions about. And the school also has to notify parties that they will be informed of the outcome of the investigation. While an investigation is going on, it may be appropriate for the school to take measures to prevent conduct from recurring or minimize contact between the victim and the accused. Sometimes that means a classroom change, a change in bus plans, or extracurriculars, but keeping them separate depending on the circumstances may be appropriate, including no contact orders, and ensuring that if no contact orders are issued, that they're enforced. There can also be safety plans put in place. And actually the rules require safety plans to be put in place in any case where physical harm has resulted or where the student who was targeted has been expressing any type of suicidal ideation, or if that person is experiencing serious emotional harm. Safety plans are also supposed to be considered in cases where the student who's impacted has been having difficulty accessing educational programs because of the inappropriate behavior. And we really do see that in a lot of cases, that students who are experiencing harassment have a lot of difficulty concentrating in school, being able to think clearly or express themselves, or suddenly lose interest in their after-school activities because they're just so impacted by the behavior. So when the school is conducting its investigation, the procedures do provide some guidance for different considerations for the investigation. Any determination about whether hazing, harassment, or bullying has occurred is supposed to be based on all the facts and surrounding circumstances. That can include the nature of the behavior, the history between the parties, whether there's been a pattern of behavior, whether there are, the context and the relationships between the parties. Sometimes it's kind of straightforward, sometimes it's a little more complicated when we're talking about different student groups and different ages. And I also want to point out the model procedures do provide that off-campus conduct, things that happen outside of school, such as at the mall or online. Those types of conduct could be considered in an investigation where there's an impact on school, on what's happening at school and the learning environment for the target of that behavior. So it provides that the impact of off-campus conduct may be considered if that conduct can be shown to pose a clear and substantial interference with another student's equal access to educational programs. So that's the language of that. And, that can be a hard thing to show, but if a parent is involved in maybe advocating for the student who's been impacted and making clear to the administrators and or the investigators that there's a real issue going on that's impacting their child's learning, that could help to broaden the investigation where appropriate. And then an investigation is actually supposed to be completed rather quickly. So within 5 school days, absent some special circumstances like a large number of witnesses to speak with, or difficulty, with one witness being absent or something. But in most instances, they have 5 days to complete an investigation. And that includes writing a report. That includes a summary of findings and an analysis of whether hazing, harassment, or bullying has occurred. And the procedures do define what hazing, harassment, and bullying means, and that's the type of analysis that's supposed to happen. It's important for everyone to know that that investigative report stays within the school. It's confidential. It's not going to be shared with parents. But if there is a complaint filed with the Department of Education or with our office at the Human Rights Commission, we do, as part of our investigation into the complaint, we do often review those investigative reports. So even though the parents are not likely to get a copy of the report, within 5 days of that completion, parents are expected to be notified of whether the school found that hazing, harassment, or bullying occurred, and reminded about the confidentiality of the disciplinary information that may be related to that. So when we talked about in the beginning of my presentation about how you're going to be notified of the outcome, really you're just going to be notified whether the complaint was substantiated. And if it is substantiated, there's a lot of requirements in the model procedures that are really important. This is really where, change can happen. The school must take prompt and appropriate disciplinary action or remedial action that is reasonably calculated to stop the harassment and prevent it from recurring and remedy any effect on the victim. This can mean that harassers may be disciplined and that they may receive education or training about the harm of their conduct. Sometimes it's necessary and appropriate to institute community-wide education or training, depending on what's happened. That may mean the class needs some more training, the whole class, or the entire school, and or the staff, so that folks are more educated about what harassment, hazing, and bullying impacts are, and in more welcoming, respectful ways to conduct themselves. And the schools should take steps to eliminate any hostile or threatening environment and support victims being able to access all the school programs that are available. And the school needs to take action, making clear that everyone involved in the matter is aware that retaliation is prohibited, cannot be retaliated against for participating as a witness or for reporting harassment, hazing, or bullying. And it's important that the school make sure that anyone involved is aware of the mechanism to report any further incidents that occur. The school has its own duty to prevent retaliation. So if they don't know what's happening, they can't, stop it. And the procedures do state that the school should provide some follow-up, should make inquiries to follow up with students who were involved and check about whether retaliation is occurring. And this is something I definitely, I think is really important to help students who have been involved in these incidents continue to feel safe. Sometimes it's like, oh, the investigation's over, and then what, and it can be very unsettling for folks who have gone through that to not know that there's still channels of communication open to them to report anything more that occurs. And there are a lot of notice rights that the parties have in these instances. Complainants have to be notified of their right to have an internal review by the school of a determination. Like if the school found that harassment had not occurred, that can be reviewed internally but at the request of the complainant or their parents. And they can also request an independent review of a final determination, as well as an independent review of how the school responded to harassment. And there is a list of independent reviewers that has been that is available through the Agency of Education. The cost of an independent reviewer is not borne by the people requesting it. It is borne by the school. And complainants finally must be notified that they have a right to file complaints of harassment, either with our office at the Human Rights Commission or with the Department of Education's Office of Civil Rights. And then it also, there are rights that the students who have been accused of hazing, harassment, or bullying have to appeal those determinations. Students accused of committing hazing, harassment, or bullying must be notified in writing of their right to appeal that finding or the discipline that resulted in it. The appeals go to the school board, and they must be made within 10 days of that notice. And the school board reviews the record of the investigation in order to determine whether the fact finder abused their discretion. The school board is supposed to hold a hearing as soon as possible, but at least within 30 days of the appeal. A bit about confidentiality, because I know this is a really hard issue for parents who are involved in these cases, that parents and I think school administrators really struggle with. The school is bound by confidentiality laws for all student data, and it cannot disclose the identities of students to other families. And if a student is disciplined as a result of a complaint, the school is not authorized to inform the victim's family, for instance, of that discipline, unless the disciplined student's parents consented to that. So what this often means is that families of students who have been victims of hazing and harassment and bullying do not know what, if any, discipline was imposed on the perpetrators. I see administrators struggle with that, and I see families struggle with that all the time. And it's a result of federal law that protects the privacy of student information. So a lot of times folks end up filing complaints with us because they don't know. They don't know whether the school has done anything to protect their child. And it can be a genuinely frustrating reality, I think, for everyone involved. So there are some other components of the the procedures, but I tried to just pull out what I thought was the most significant parts that we hear about the most. And I just wanted to give you a brief overview of what happens once a complaint is filed with our office. So if a family or a student want to bring a harassment complaint to our office, they start with an initial complaint intake process with our one staff person who is our executive staff assistant. Then if we accept the matter for a complaint, we will assign a staff attorney investigator to conduct an investigation. Investigations involve sharing the complaint with the school and giving them an opportunity to respond to the allegations in the complaint, produce any documents they have that are relevant to the matter. And then we typically will interview the parents. If it's age appropriate, we'll interview the student who was victimized. And then we will undertake interviews of administrators, witnesses, whoever else might have relevant information. We have very broad investigative authority. As you can imagine, that can take quite a while. We also will look at any documents that any of the parties want us to see. And sometimes after interviews, we need to conduct follow-up requests for information. But at the end of all of that, there is a requirement that our investigators produce an investigative report. This summarizes the investigation, the facts that were found, and contains a pretty in-depth legal analysis of whether or not discrimination or harassment occurred. Our reports are submitted to the parties. They're confidential at this point in the process, and the parties are given some time to review our reports and submit a written response to them if they want to, about whether they agree or disagree with the recommendation of the report. So our reports make a recommendation about whether or not discrimination occurred. Those reports and any responses from the parties are reviewed by our commissioners at a commission meeting. They take place monthly, and it's an executive session. Parties are invited to attend a hearing and answer any questions that the commissioners may have and make a statement about the report. And then the commission makes a vote in the public session about whether or not they find that discrimination, that there's what we call reasonable grounds to believe that discrimination occurred. And at any point from the filing of a complaint to a commission hearing, our staff is tasked with making every reasonable effort to assist the parties with a resolution. They call it conciliation under our statute, but it's really settlement conversations. Our investigators are not representing any party in the case, and so it can be a really helpful avenue for like having a go-between for communications to see what the parties might be able to come up with to resolve the complaint, and to meet their needs. So conciliation can happen anytime, and if there's a commission determination that discrimination may have occurred, this opens up under our statute a 6-month time period where we will again be trying to do conciliation. And if we aren't able to do that, we do have authority as the Human Rights Commission to bring a complaint of discrimination in Superior Court. But at any time, a party can bring an enforcement action. They can bring their own civil claim under the Vermont Public Accommodations Act, alleging that discrimination or harassment occurred at the school. So that's kind of the broad brush of our process. And I'm going to turn it back over to Amanda Garcés for a few final remarks.
Big, I wonder if we take just a little break to answer some questions in the chat before we
Sure.
switch to this.
Okay, so I can go ahead and read the questions for you. At times, students with difficulties have subtle differences in how they conduct themselves when compared to their peers. Sometimes this creates a situation where peers notice them as different and may bully them in school as a result. Would this be considered harassment?
So that could be considered bullying in its own. But if a student is perceived as having some kind of disability, whether that be mental or cognitive or intellectual, that could be considered harassment under the law as well.
Okay, and you had mentioned those timelines with the school, the 1 day, the 5 days. Who actually enforces those timelines if they're not met?
Great question. The school is responsible for following its own procedures, and there are the procedures do allow some wiggle room on the deadlines there because it says under special circumstances they can have more time. If a school was not following the timeline at all and was taking much longer, we could consider that as failure to take prompt and remedial action, which would be something that could be a complaint with us.
Oh, okay, with the Human Rights Commission.
Yes.
Okay. Can
But I would also say, like, going to the school board or to the district level can be another avenue for parents to try to get action faster, and probably is a more efficient process.
Okay, can parents of students with disabilities ask to be present at an interview conducted by school staff as part of a bullying harassment investigation? And then related to that, parents often ask if the school districts are allowed to interview their child who is a minor without the parent present.
Great question. I'm not aware of anything in the rules or the procedure or policy that prohibits parents from being present at an interview that their child is asked to give. I will say in the investigations I've seen, they're pretty brief, and I have not seen a case where parents have been present, but I have not seen a case where a parent has asked and been denied either. So if there's concern about that, that's where it's like important to try to do advocacy for yourself and your child to ask if possible, if you could be present.
Okay. Do you, with the Vermont Human Rights Commission, do trainings for the school's designated employees?
We're finding out that historically, the Human Rights Commission has been a resource for these types of trainings. And I think we do have a vision that we will have capacity to do some trainings ourselves. There are many different places where that training can be provided, and not just from us, but we are hoping to be able to provide more of those. Also, like proactive prevention oriented trainings that aren't just about how to follow the process, but more about how to protect students before we even get to a complaint being filed, so we can avoid that if possible.
And do we know who might be providing any of the trainings now then to the school's designated employees?
I believe that the school's designated employees are getting training through the school district association, the school board association, and their representatives.
Yeah, there's a couple of lawyers around the state who are hired by the school districts who are doing the training. So I know that the Vermont Insurance Trust, VISBIT, which is part of the school board associations, who insures the school, a lot of the districts in Vermont do have an attorney who developed toolkits for them Heather Lynn, who does a lot of the trainings for the school districts. But that's training specifically to the policy and how to follow the policy.
And I will say my experience of doing investigations with administrators who have received that training and those who have not, it can be a world of difference just to get that training. And it does sound like it's a very in-depth, several hours long training for administrators about how to respond to complaints.
And is any training required, or is it just up to the school districts if the employees will be trained?
I am not aware of an explicit requirement. Amanda, are you?
I think the designated employees are supposed to get trained, but we'll get back to you on that.
Okay, thanks. Can you speak, because we noticed in a previous slide where bullying was defined only as student to student. So can you speak to the issue of adults in schools who bully students, and what would the process be there?
I believe that would be that would still be something that is captured under the hazing, harassment, and bullying procedures, even if it was conduct committed by an adult.
Okay, so a parent would still go through the reporting process and the school would still have to follow those same timelines to do the investigation. But until it rises to the level of harassment, it would not go, well, to you.
Correct. And harassment versus bullying, the main distinction is really about whether it's because of a student's membership or perceived membership in a protected class. So it's not really about the severity of the conduct, but about what's motivating it.
Okay, a question did come in before the workshop, and even though it's not exactly the same topic, I'll read it anyway. So in a title, we believe it's 9. Does the school have the right to give your sexual predator your physical address, date of birth, phone number, attendance?
It's certainly my understanding that information, personally identifying information, would be legally protected as confidential under FERPA, that which is federal law. And although I think there are exceptions, for instance, if you consent to your identity or your child's identity being shared in an investigation, that's a different story. But if you don't consent to that, and the assumption is that any personally identifying information would be confidential. Although, I mean, obviously, when a student is getting interviewed about conduct involving another student, they're likely to figure out who we're talking about, right? In order to provide the basic information about the facts. But the school itself should not be sharing that level of detail to anyone.
About how many cases do you investigate in schools a year, on average?
At our office right now, we have about 50 complaints open right now involving all of our cases. So only a small subsection of our total caseload is schools. We probably have at a given time 5 or so going on, and they can take a very long time because it's usually a complex set of facts.
Okay, so let me finish the rest of the presentation, and then we'll end with more questions. So this is the hard part, that sometimes bullying and harassment is unseen. So as parents, some of our kids are not, maybe we don't know that that's what's happening. So there are some great resources from the Stamp Out Bullying website, that is a national resource organization. But like, what are the signs? Like, how do we know that our children are being, and it comes with the extreme of coming home with torn or damaged clothes, to just unexplained cuts and bruises, to just not wanting to go back to school, to not being able to do their homework, to being afraid to, get on the bus, or fighting that because usually we see that bullying harassment happens in what we call the third space, which is not in the classroom, but it's either in the bus, it's happening in the cyber world, or it's happening on the hallways, in the bathroom, where maybe the adults are not present. So if the child is taking long routes to go to school, or not showing up at school, if they're moody, they're teary, they're not eating, they are having nightmares, frequent sleeping, those are signs to kind of the anxiety, low self-esteem are signs. We can go to the next slide. Babe, can we go to the next slide? So we see that, bullying, we see as the power imbalance. Again, that is like one of the biggest pieces around bullying, and harassment, that there is a power disparity there. The bully has the power, the physical strength at times. Maybe he has possessing of embarrassing information, text. There's popularity issues. They want to assert that control. And this is very important when we're talking about bullying harassment, and because it shifts over time, and sometimes it involves the same people. Usually is recurrent. So bullying incidents, we know that are repetitive nature, that or have the potential for recurrence. So when we're looking at those signs and your student is telling you once that this happened, you want to make sure that you're asking questions. How's your relationship with this person? What is happening with this person, so that you understand whether that is going to increase through time. And again, like, it encompasses various actions. So bullying can involve making those threats, spreading the rumors, engaging in physical or verbal attacks, and explicitly excluding someone from a group. And so under the Public Accommodations Act, BIG already gave us all of our legal framework that we use here at the Human Rights Commission. It is really important that we know that this overlaps, but does not replace a special educational legal requirements, and vice versa. So it's really important for those of us who have students who are neurodiverse or who are in an IEP, that we know that this is, it overlaps, but it's not separate. So just because a target or alleged perpetrator is a student with this disability in an incident of bullying harassment, does not mean that the school can, forget about the bullying harassment. So we have to just be clear that sometimes our kids are bullied, and sometimes our kids are the ones doing the bullying, and so to keep that in mind, and that it's okay, because we have to think of this work as how do we change and transform these systems that are allowing for both of our kids to be in the same place with this power imbalance. So schools should use both an approach to coordinate efforts between the designated employees and those who are responsible for carrying out the requirements of the HHB and a special education. So you do want to make sure that you know who those designated employees and whether or not you have those informations. Next slide. And so I already said that students with disabilities sometimes may bully other students, and that action is not protected just because our child has a disability. So we have to make sure that we understand that a little bit. And we know that students with disabilities are 2 to 3 times more likely to be harassed and also suspended for the same thing of those who don't have disabilities. And so, and students with disabilities who are neurodiverse also have a, very high, they're prone to be more bullied and harassed through the cyber world. And so it's to have that in mind. but they are eligible for IEPs, 504 plans, and obviously the Vermont Family Network is our Vermont resource that has all the wealth of information that they do, specifically those trainings on that. Next slide. And so if a student with a disability, I hate this word perpetrator, I should have removed it. I saw it now and I didn't like it, but it's there. For a student who is neurodiverse and did bully somebody else, there's a manifestation determination. And this occurs after an investigation is complete and the bullying harassment has been substantiated, but before the discipline is carried out. So you don't want the students to be, expelled or suspended. If the behavior is not connected to the disability, the discipline needs to happen the same way as students without the disability. And if the behavior is connected to the disability, the school needs to follow the required 504 plan and steps. Next slide. And Karen is much more bigger resource around that. So I'm sure she can answer questions about those determinations. But the students not previously found to have a disability, but who allege misconduct was due to an undiagnosed disability, the discipline still applies even if an evaluation is requested and it is conducted in an expedited manner. This is really important. I put this in here because what we see is that evaluations in the special educations take a long time. Parents are now finding out that their child might be diagnosed with ADHD that has, other behaviors that come with the stress of being in these environments that are not apt for students with ADHD. And I give you an example of my son that it took me 2 years to was like, well, maybe he does have, to request an evaluation and understand that's what he has, and that's why he couldn't, stay still. And so all those things, those are behaviors that for us, this is why it's intertwined. A lot of this is intertwined and we cannot isolate it. It's so important that we think of our child as a whole, that all of these things are happening connected and that the schools need to respond in the same way. So what happens is that maybe a child who was bullied, maybe we need to look back at their IEP to include related services that address the impact that this is happening on them and vice versa. Next slide. And then I end with what can you do? So there's a lot of work that you can do. I'm gonna put up a little brochure, flyer later, but the Human Rights Commission is part of a lot of legislative work, advocacy work around the state around this specific issue. And so we want you to be part. Your voice is really important in this work. This is how we change policy. We hope that you can collaborate with other parents so that we can amplify what is happening to our students and join our campaigns. Next slide. So specifically, there's 3 working groups in the state. The Special Education Advisory Panel that meets, I believe, once a month. I'm gonna put the link to the State Board Council. That is one that any students with disabilities, families that want to go and share their opinion on what's happening, that's a good place to be that can impact change. The Working Group on Student Protections from Harassment and Discrimination, that was passed by a legislative action in January. It's supposed to end at the end of January. And we are really currently drafting recommendations for the legislature around bullying, harassment, and prevention. I really encourage you to go and speak your mind and say what needs to happen around this issue. Really, really important. And then we have the Hazing, Bullying, Harassment Advisory Council that is not meeting currently because of this other working group, but that is a place where we need that group to also, advance this work. There's 2 campaigns that the Human Rights Commission is part of. The Let Me Be Great campaign, which is led by students, giving resources to schools and families, is really great. Narratives for Change with the Vermont Family Network is part of, and that's a really important one because it's a storytelling campaign around bullying and harassment. So this is where you can share your story so that we can push the legislature to do more. And then there's a list of all these organizations throughout the state who are just really wealth of resources, really amazing people, just giving it all to make sure that our education systems work for all of our students. And so I ended there with.
And here are just a few citations and legal resources for more information about our legal framework and the agencies who are involved with enforcing those laws. So I think that concludes our slides. We went a little bit over. Sorry about that. There's so much to talk about on this issue. I'm going to stop sharing, and I think we're happy to stay on for some more questions and answers.
So if anyone has any questions, feel free to unmute yourself and ask, or type it in the chat. If not, we are going to be wrapping up because we are pretty much at time, but certainly if you have any other questions after, to go ahead and contact the relevant person. I believe all of our contact information will be available on the presentation, and I see that Manda has put a link on the chat as well. So we have our evaluation
Okay,
in our
you
chat,
have your
and
own?
Amanda also does have an evaluation.
Well,
so.
if you already have yours, it's okay. It's better. Yours is better.
No need to do two.
No, you don't need to do two.
Yes, but would be great if folks can take time to fill in, at least one of them. So again, we have many other interesting workshops coming up, and you can find details about those on the homepage of our website, vermontfamilynetwork.org. We have tons of information on our website. Getting connected with us is easy. You can follow us on Facebook or join our closed Facebook page if you are a parent. You can also sign up for monthly e-news or check out our YouTube channel. So we at VFN, as well as them at HRC, are here to help. So contact us by phone or email. And thank you, everyone, and have a great day.
Thank you.